All right. Well, good afternoon, everyone. My name is Alejandra Barger. I'm the director at Team Project. Today we have guest speakers, Alison Packard, in collaboration with Consolidated Planning Group with Alison Packard. So thank you so much for being here this morning. Before we start the presentation, I just wanted to let you know a little bit more about Partners Resource Network, if this is your first time joining us. Partners Resource Network is the Parent Training and Information Center of Texas. We are federally funded through the Department of Education Office of Special Education Programs, and we provide free services to parents of children with disabilities, as well as youth, self-advocates, and professionals. All of our services are free of charge as well. Our mission is to empower and support Texas families and individuals impacted by disabilities or special healthcare needs. We serve, as I mentioned, parents of children and youth with disabilities from the ages of 0 to 26, as well as youth self-advocates from ages 14 to 26. As you can see from this map, this is our service area. Team Project covers the red areas, which are regions 13, 20, and 1. And then the other remaining projects cover the rest of Texas, but anywhere you call us, we will be able to serve you. Our free services include some of parent workshops, youth workshops, information and referrals, one-on-one, art IEP support, annual symposiums, and parent and youth leadership trainings. And you can visit more of our services in our website at prntx.org. Just a few housekeeping items. Please submit all of your questions either in the chat box or the Q&A box, and Alison will be able to monitor those and ask them at the end of the presentation. As you notice, we are recording this webinar. All recordings will be shared on our Facebook pages and via email to all attendees after this session is done. Also, at the conclusion of this webinar, you will be redirected to another page that has our evaluation. We ask that you provide us with your honest feedback to improve our services and our webinars in the future. And last but not least, we do not provide CEUs, only certificates of attendance. So if you need one, please send me an email. I will leave my email in the chat box and I will get those out for you as soon as possible. And here's my contact information. Phone number 832-720-2127, and my email address, abarger@prnteam@gmail.com. And like I said, I'll put that all in the chat box. And thank you everyone for being here today with us. Alison?
Thank you. Thank you for having us back again with you today. I'm going to share my screen. Let's see here. Here we go. Okay, Alison Packard here, Consolidated Planning Group. We're always happy to be back with Partners Resource Network. Today, I am super excited to be hosting Alison Packard. Alison and I met through Texas Partners in Policymaking. So we worked grueling hours on that project over a 9-month period, and we got to know one another really well. So Consolidated Planning Group, we are a holistic special needs financial planning firm. And then Alison Packard is an attorney with her practice really, focusing on working with special needs. Her and we share the same name, different spelling. We also share in the fact that we both have children with special needs ourselves. So we work in this professionally, but also personally live it day in and day out. And so one of the things that I want to share before I turn it over to Alison is the differences of what Consolidated Planning Group does and what Alison does, because a lot of times there's confusion. We get a lot of calls asking about the legal documents, which, all of our families need these things. But I kind of say it tongue in cheek that Alison Packard, she is the paper. She's the legal documents. These are the documents that you're going to have. And we don't do that. But we're the money, okay? We're the ones that make sure that the money's in the right buckets, that there's enough funding for your loved one in the future. that when you're no longer here or incapacitated, that, if you have a child that's going to need care for the rest of their life, we're the ones that make sure that the money's in the right buckets and the money is there. We do the Social Security analysis. We do kind of, all things financial and everything tied to Social Security and retirement. So when it comes to special needs planning, you actually need both of us. So Allison doesn't do what I do, and I don't do what Allison does. But together, we work hand in hand as you're kind of going through the planning process. So having said that, I am going to turn everything over to Allison. And today we're going to be talking about guardianship and the alternatives to it, which I would say is an ongoing buzzword that we hear in the special needs community over and over and over again, especially if you're in that transition phase. So thank you so much, Allison, for being here with us today. Turning it over to you.
Thank you so much. It's a true privilege to be here and present such wonderful programs such as this. Okay, so as Allison mentioned, I do this professionally, do special needs trusts, guardianships, these kinds of things, but my real expertise comes from being a parent. And I'm assuming we're talking to mostly parents, so that's sort of how I'm going to refer to everyone as parents, and that of course includes grandparents, and I hope that's okay with any professionals on here. So when we look at guardianship or alternatives, we need to think about our kids when they hit age 18. When they're 18, they are now adults, and they have the authority to make decisions for themselves. We as parents are going to lose that authority. And Allison, I don't know if you want to hit the slides and skip over to, yeah, you can skip that. Okay, yes, so our kids, when they hit age 18, now our third authority as mom or dad ceases. So we have a few options. Our kids can now, our adult children can now either represent themselves, we just move on like, happens normally, or we can have a guardian appointed, or we can look at a less restrictive alternative. Now, let me just give you an overview of what guardianship is. This is a tough decision for a lot of us. A guardianship involves the court. When we get a guardianship, what we're doing is having the court determination of incapacity and need for appointment of guardian. So this is not something you just do by coming into someone's office and signing a paper. You have to go to court for a guardianship. A court will grant a guardianship if someone is found to be incapacitated. Definition of incapacitated person is here on the screen. An adult who, because of a physical or mental condition, is substantially unable to provide food, clothing, or shelter for himself or herself, or care for the person's own physical health. So as you look at that definition, I know that a lot of us as parents, we think, oh yeah, that's my child right there. I know that's my child. I can see it. But it's not just what we as parents think. We've got to have medical support for this. So on the next screen, I have a reference to a certificate of medical examination. This is the medical evidence that is needed in a guardianship case. The judge is going to want to see this. We call it a CME for short. And on this CME, the doctor, and it's got to be a doctor licensed in Texas, needs to be a physician, not a physician's assistant, or could be a psychiatrist, but not a psychologist. So we're looking at an MD or a DO. And so on this form, the doctor is going to indicate whether or not our kids can make their own decisions about where they live, about getting married, voting, driving, making their own medical decisions. And the doctor is going to indicate yes or no. And this is just, it's kind of hard to see this, but this is just one of the pages. But if you see on section 5, there's a whole bunch of boxes. Yes, no, yes, no, yes, no. And depending on what the doctor indicates there would really determine whether or not this is a full guardianship, a complete guardianship, or a partial guardianship, or a limited guardianship. If the doctor indicates that this is a full guardianship, then that means our child will have their rights removed to vote, to drive, to marry, to make their own medical decisions, choose where they live. So it's something very significant. If we have a limited guardianship, then they can retain some of the rights. So for example, the doctor might say, yes, this person can continue to vote or maybe drive. And then it's possible to do a limited guardianship. But most of the times, if the doctor thinks the incapacity is serious enough to not be able to make marriage decisions and medical decisions and choose where someone lives, a lot of times it's going to be a full guardianship. And I will say courts seem to be in favor of allowing someone to keep the right to vote. That's the one I see most often retained, because that's a personal right. And for some people who really want to have that experience, the judge isn't going to object to that in most cases.
Alison, can you tell us where does a person get this form? So this has to be signed by a physician. Where do they get this form?
Yeah, great question. You could probably Google it. Just Texas Guardianship Certificate of Medical Examination. If you want to email me, I can certainly email a copy back to you. I will say you need to use the most recent form because it has been changed. The most recent form is a 2017 version, so it's not all that recent. But if you use an older version, it's not going to have all the correct questions on it. So if you're unsure about that, feel free to email me, Alison@packardfirm.com, and I'll send it to you. This is going to be the same form you use across the state.
And we'll have her contact information at the end as well. And then one other thing I just wanted to hit on here, you know, at the bottom of that form in number 6, it says intellectual disability. So basically you said, you know, full guardianship, basically there's limited, or some people refer to it as partial guardianship or something like that. There are multiple options. I know you're going to talk about it through your presentation, but in the example, so let's say, you know, again, it's not a matter of, you know, what a parent thinks, but let's say in the example that a parent has a child with intellectual disabilities, their IQ is 70 or below. What is your threshold? Because we get this question a lot of, so if a parent is considering supported decision-making and a power of attorney, does an individual with an IQ of 70 or below represent a person that could sign a document like that and actually know what they're signing?
Yeah, that's a great question. I would say anyone with an intellectual disability, I personally, as an attorney, I'm going to be skeptical about whether or not they will understand that document. I have allowed people with IQs below 70 to sign those documents, but I really, really press them for their understanding. Sometimes those IQ tests might not reflect the ability to understand that document, but as a general rule, if you have an IQ below 70, I'm going to be very, very hesitant to let you sign that kind of document in my office. Because again, and we will get into this, although a medical power of attorney, a statutory durable power of attorney, those are great documents to avoid a guardianship. There's no legal validity to those documents if you don't understand what you're signing. And so a lot of times we'll have parents who just put that in front of their child, but if the child will sign their name, but if they don't understand what they're signing, it's not a valid document.
Sure. Plus, they could revoke it at any time anyway, too. So
yeah, another great point. Yeah. Okay. If you want to go to the next screen, I think we've talked about that. So I do want to clarify the difference between guardianship of the person and guardianship of the estate. Guardianship of the person is when you are the guardian to make medical decisions, choose where the person is going to live, make educational decisions. Guardianship of the estate is managing money. And those should be distinguished because in my practice, and I'm guessing based on the people on this call, for most of us, we're really looking at guardianship of the person. We can typically avoid the guardianship of the estate. And we'll get into that a little more if you go to the next slide. In Texas, just for the last few years, we've had a lot of guardianship reform. And so guardianship, it used to be that everyone just got guardianship as a matter of fact, and it wasn't really thought about carefully. And so there's been a big push to really think about it before you go get a guardianship of someone. And one of the new requirements of in the law is that we all consider alternatives to the guardianship and supports and services before we go ask for a guardianship. So before a judge will appoint you as a guardian, you have to show and put on evidence that you did consider alternatives. So let's go through a few of these alternatives. And Alison already mentioned a couple of these. But an alternative for guardianship of the person, a less restrictive alternative would be, well, a guardianship with limited authority or a partial guardianship. It's still a guardianship, but maybe it's not as severe. And then we were just talking about medical power of attorney, durable power of attorney, supported decision-making agreements, or declaration for mental health treatment. And if you'll go to the next slide, let me just touch on a little bit more on the powers of attorney. For a medical power of attorney, the agent gets appointed to make medical decisions for the person who is incapacitated. That is something I should sign. All of us should have a medical power of attorney so that if we become incapacitated, someone can make decisions for us. And the doctor decides when this kicks in. So this is not a document where you just take over making medical decisions. A doctor will decide if the person has lost their capacity. And as we already mentioned, you cannot sign one of these medical powers of attorney unless you understand the document. And as we also mentioned, of course, anyone can revoke that. So I can name a medical power of attorney agent and then change my mind next week and appoint somebody else. And that is something to think about with our children too. If they are able to sign this document, if we say that our kids have the capacity to sign this document, then if they choose to revoke it and appoint their girlfriend or their boyfriend or someone else, then we have a tough argument because we've already said they had capacity to know what they're doing.
Allison, I wanted to chime in here on this medical power of attorney because I think oftentimes our focus is always around our special needs kids and what's going on with them. But this document is a very, very important document. You should have one, and you should have meaningful conversations with your aging parents to make sure that they have one and who they have appointed is still holds true. And then furthermore, when you have a child, your neurotypical child that you're sending off to college, this is also an important document that you want for your student going off to college as well. So this is just something that we think that gets overlooked on a pretty regular basis. It's something that's done and then it's put on the shelf and never looked at it again, or it just never got done. So we always just like to mention that for the whole family, not just your special needs loved one.
Great point. Thank you. Okay, this power of attorney, so this is another type of power of attorney. This is sort of covering everything other than the medical decisions. So this is going to appoint someone to have the power to make decisions for you about schooling, educational decisions, vocational training and employment, signing contracts. This kind of power of attorney can be effective the moment you sign it, or you can indicate that it's only effective upon your incapacity. So if I want to sign it and appoint my husband as my power of attorney agent, then he can go sign documents to sell a house or buy a house or get into my bank or whatever immediately. Or I can say only if a doctor says I'm incapacitated. So again, if someone has a high enough intellectual functioning and they could understand this power of attorney, it might be a way to avoid the guardianship by just appointing an individual to make these kind of decisions, to sign documents, sign lease agreements, these kinds of things. But again, remember, a person signing a power of attorney, they have to understand what they're signing. Okay, the next screen. And
we have a question, if you don't mind, if I ask.
Yeah,
in the example, what if a child is high functioning, and they get coded as in school, but the IQ is borderline, stuck right in the middle? What do you suggest? My son talks and walks and reads, but when it comes to numbers, he can't master this. He's not functioning as a 16-year-old mentally, maybe around 3rd or 4th grade.
I would say there are a lot of kids, and honestly, my child's in this category too, where it is a tough decision. Can I do a power of attorney? Do I need a guardianship? So I would recommend going and visiting with an attorney, letting the attorney kind of assess whether or not there's enough capacity to sign that legal document. Again, with a lower IQ, if it's me, I'm going to be really skeptical and I'm going to be super careful, but I have done that in some cases. But I'll really talk to that person, make sure they understand. We'll read the document together. It usually takes a bit of a longer time. If you think your child is borderline, then one thing you could do if you're trying to get them to sign a power of attorney is get a copy of the power of attorney, read it with them, cover it with them, talk about what does this mean, have them prepared so that when they come see the lawyer, they know what it is they're signing, they've seen the words, they know what they mean, and that'll make it easier to assess enough capacity. I hope that answered your question. And by the way, if anyone out there wants to just kind of talk this over with somebody, give me the specifics of your case, then feel free to call me. My number will be at the end, and I'm happy to just kind of brainstorm with you. I get it. It's a really hard decision in a lot of cases. Any other questions?
One other thing, Allison, we've got something, that comes up all the time. We've got kids that are ADHD, on the autism spectrum, for lack of a better term. Sometimes I say late to the party. So what I mean by that is, from a maturity level, they're not quite there yet, but we're still hopeful and optimistic that they're going to get there. But clearly when they're 18, they're not there. So if they did some type of limited guardianship, or some kind of, maybe not full guardianship, but limited or something, it's not in stone forever. It could be dialed back. So if this child matures and they move in the direction that we hope that they will, and they don't need this anymore, can we undo this if we do this?
Yes, it is possible to undo a guardianship, but I will say it is a serious procedure. You've got to go back to court. You've got to get the same physician's certificate of medical examination completed. Only this time the doctor is going to say, yes, you can do this. Yes, you can do this. There's going to be a lot of yeses instead of nos. But it happens. I've done several restoration of rights. I've done complete restorations of rights and partial. And so it is possible, but it's expensive and it involves the court. So it's not something you want to just say, well, I'll get a guardianship for now and I'll change it next year. It's a pretty significant thing to get that restoration of rights. And it involves a lot of witnesses, because once the judge has said that your child is incapacitated, getting that judge to say now the child does not have, or an adult child does not have an incapacity, you're going to need a lot of testimony. So sometimes it's an expensive procedure. But yes, definitely.
One last question.
Mm-hmm.
We've seen a rise in major mental health crises, more so since COVID has been going on. I mean, it's been an ongoing thing for a long time. But what about the child that has significant mental health diagnoses, but maybe isn't on the autism spectrum, and IQ isn't below 70? I mean, they have capacity to understand, but have regularly been a threat to themselves or others. Can you talk about that?
Yeah, that is a really tough situation, because a guardianship is for a person who has a continuous disability. And so a lot of times when we deal with mental health, it's up and down, and there might be a period of time where there's really good functioning and then a crash. And on that physician's certificate, the doctor is going to have to indicate that this is an ongoing problem, that it's continuous. And so a lot of times if there's too much up and down, then the guardianship is not going to be granted. The other thing to consider is appointing a guardian sometimes does not solve all the problems that we have to deal with when there's mental health issues. For example, the guardian can say you will take this medicine, but getting the medicine down, sometimes it's not that easy. It's, as a guardian, you can drive someone to be admitted. You can ask to be evaluated rather, but you can't force an admission in a mental health hospital. Only a doctor can do that. So now when the person's released, they'll call the parent or the guardian, but I'm saying it won't solve all the problems. So again, if you've got that situation, feel free to call me. We can talk it through. We do guardianships in many cases for mental health reasons, but others, we just realize it's not going to solve the problems that we're trying to solve. So call and talk about this. Okay, this is just what, Allison, you already mentioned. Powers of attorney are for everyone, college kids, elderly people. We should all have these in place. Okay. As part of the guardianship reform that we've seen in Texas, we were the first state to create what's called supported decision-making agreements. And the theory behind supported decision-making agreements is that it takes practice to learn how to make good decisions. And people with disabilities need to have that practice. And so we don't want to take away their right to make those decisions. We just need to give a little extra support. And so a supported decision-making agreement is where the person who needs a little extra help, they can appoint what we call a supporter. And you don't have to go to court. So this is not like a guardianship. The attorney doesn't need to draft the agreement. You can find plenty of samples on the websites for ARC of Texas, Disability Rights Texas. I have samples. You can use an attorney, but you don't have to. And the principal or the person signing it, their capacity can be a little lower. You don't need, it's just not as hard to understand a supported decision-making agreement. But one thing you need to remember about supported decision-making agreements is this: if I'm listed as my daughter's supporter, it gives me no authority to make a decision for her. It just means that I can give her counsel and advice. I can help her communicate. I can relay her thoughts to the doctor or to, whoever I need to talk to about it. And so I think it is a wonderful theory, a wonderful philosophy to let our kids keep as many rights as possible, help them make decisions. But honestly, I don't recommend relying just on a supported decision-making agreement. There will be a lot of people that say this is an alternative to guardianship. But if it turns out that we need to step in and make a decision, there's no right to make a decision there. So I always tell the people I work with, if you have the ability to sign a supported decision-making agreement, we'd like it to be backed up with a springing power of attorney, a power of attorney that goes into effect if the capacity is lost or there's some extra help needed. I hope that made sense. If you go to the next slide or two, Allison, there is a sample, one more slide. There's a sample, just a screenshot of what the supported decision-making agreement looks like. And you can see it is very simple, easy to understand. So that is a huge advantage of the supported decision-making agreement. But again, my personal recommendation, try to back it up with a medical power of attorney. So if I can talk to the doctor with my child, but then if she becomes incapacitated, now I can take over and make decisions. And I'll just, tell you my perspective as a parent. I did one of these with my daughter and I was so excited about it. They were new and I felt like we were cutting edge, disability rights and everything. And I just never really used it. I've never had a doctor say, Ms. Packard, stop talking. Let me see your authority to give your daughter advice. I just never was asked for it, other than one time my daughter was in a school program that was too difficult for her. And she said they were talking about having her drop out. And I said, it was a program for special needs kids who had IQs below 70. But I said, tell them you have a supported decision-making agreement. You need me there to decide. And that was the one time I used it. But honestly, power of attorney would have worked just as well. So I'm not down on the philosophy of it. I'm just not seeing as much use of it as I would like to see. So I don't have one for my daughter anymore. But
that was a question that has come up before of like, do I really need to document the supported decision making? Don't I do that as a parent anyway already? So it made me laugh that you said that, because I kind of have thought that before. And the truth is too, that a lot of physicians don't even know what the supported decision-making agreement is. They're familiar with the healthcare power of attorney and a power of attorney, but a lot of people are even at the bank or something like that, I don't know, a lot of them are somewhat confused by it. But we do see them, but we often see them. In fact, I haven't really seen them not backed up by a power of attorney like you were talking about and the healthcare power of attorney. So I think that's important.
Yeah. Now I will say, if it's not a parent, then maybe that would be a better use of it, because I think doctors are going to be comfortable with a parent being involved, and most of the areas where our kids are involved in school and whatever they're doing, parents get welcomed in much more quickly than, say, a sibling or someone who's not a parent. So maybe it would be more effective in that situation. But let's keep going. Guardianship of the estate, we've got plenty of alternatives. As I mentioned, I rarely do guardianship of the estate for parents of adult incapacitated children. And that's because we can usually find a less restrictive alternative. We did talk about supported decision-making agreements and the powers of attorney for finances. That would basically, if you had a power of attorney, then that person could manage your bank account and take care of your finances in that capacity. So they wouldn't need to be a guardian of the estate. The most common ones that I see are Social Security representative payee. So a lot of our kids, mine included, receive SSI or SSDI, and the Social Security Administration will allow us to be a representative payee, which is kind of like a guardian for Social Security funds. It only is handling those Social Security funds, but it basically, you're treated just like a guardian would be treated. In most cases, there are a few things that your child will still need to sign, or you will sign in your capacity as a guardian, but for the most part, being a representative payee will cover it. And let me say one more thing about the Social Security representative payee. The Social Security Administration will not take a power of attorney. Okay, so if you have a power of attorney and you take it there, they're going to say, that's really nice, we don't take that. They will take your guardianship letter to help maybe get the application going and do some things, but they're going to want you to immediately become a representative payee, even if you're a guardian. And it works great. So if you need help on that, refer to my slides or give me a call. But it's real easy to do. The other major alternative to this guardianship of the estate is a trust. And if you'll skip down to those slides, Allison, what a trust is having somebody who manages funds for the benefit of somebody else. So the trustee is the person who has ownership of the property, but all the property, all the money can only be used for the benefit of the beneficiary. So this is super common in our world where we have special needs trusts. And these are trusts where we have a trustee appointed to manage funds that are left for our kids, okay? And it's important to understand that a trustee is not a guardian. We're avoiding the guardianship of the estate, but a trustee cannot make medical decisions, cannot sign school records, cannot decide where someone lives. A trustee is only over those funds in the trust. So typically what we'll see to avoid a guardianship of the estate is we'll have a special needs trust to manage property that is left to that trust, or inheritance, life insurance, that kind of thing. And then we'll have a Social Security representative payee to manage the Social Security funds. And Allison, if you would skip to the next couple of slides, we don't have time to really get into this, but I do want to emphasize, if you're here to learn about guardianship, make sure you know about special needs trusts. These are important trusts to understand. There's two kinds of trusts, one with a Medicaid payback, one that doesn't have a Medicaid payback. And all of us who are considering guardianship and alternatives and have kids with serious special needs, we need to understand about trust. Okay,
Allison, I just want to chime in here. We do have webinars about first party and third party special needs trust. It is important, and it might not be important yet because maybe your child hasn't turned 18 and they're not getting SSI. But basically, the special needs trust, whether, you know, first party, third party, and an ABLE account, those are buckets of money where you can have money that's basically not going to be counted against you as an asset for SSI. So it's real important, and this is a cause of a lot of confusion for people. So we'll go deeper and wider with this on another time. But thank you for bringing that up. I appreciate that. It's very important.
Yeah, and let me add one more thing in the guardianship context. Estate planning is so critical for us as parents of kids with disabilities, because if we don't do that estate planning, and you know, if my will says everything to my husband, and then if he dies to my kids, you know, a typical will, or if we don't have wills, then the money is going to flow to our children, and it is going to just cause all kinds of problems with those government benefits. And what will likely happen is there will end up being a guardianship of the estate created. We could end up getting all that money moved to a special needs trust, but at that point, you're looking at a first party special needs trust, which has a Medicaid payback, and then you're in the guardianship court, and you're going to have all kinds of extra fees. You know, I didn't really emphasize this before, but the reason we want to avoid these guardianships of the estate is you have to do an accounting every single year, and it's going to be very high attorney's fees. So we want to avoid that if at all possible.
I want to echo that as well. When it comes to this estate planning and beneficiaries, I actually really try to mention this on every one of our meetings. Most commonly, what we see people do as it relates to beneficiaries for your life insurance, beneficiaries for your 401k, 403b, pension, basically, we name our spouse as the beneficiary if you're married. And then as contingent beneficiaries, so if you die and then your spouse is already deceased, then as a contingent, that's easy. I'm going to name my 4 children equally by name. And that is very common. And if you have done that, it is incorrect, but you can fix it, and you can fix it for free by just getting a change of beneficiary form. Of course, you do have to have, you know, the trust set up and things like that, but it's wrong for 2 reasons. It's wrong for your neurotypical children that are under age 18, because basically that money is going to sit in trust until they turn 18. And when they get 18, they're going to get large sums of money with no direction, which is a bad idea. And it's wrong for your special needs child because basically they're going to go over that asset limit. So I'm glad you brought that up. The asset limit for SSI, it could cause them to disqualify from SSI and Medicaid. And of course, you can pay, a legal, you can pay Allison to have it redirected to a first party special needs trust, but then those assets are going to have a Medicaid payback. So we'll come back, we'll just kind of go back to this, but I think it's always important to spend a little bit of time on that, because we see that every single week, we see those just common mistakes out there.
Yeah, great point, Allison. Okay, let's keep going. The slide that's in front of us about successor guardians, this also ties into estate planning. We all should have in our wills somebody identified as a guardian for our children if we think a guardian will be needed. We always want this for minor children, but if we have adult incapacitated children that either are under a guardianship now or could be under a guardianship in the future, you want to make sure you indicate that in your will, who should be the guardian. And especially if there's someone you do not want to be the guardian, you need to specify that. There are separate documents you can do if you don't want to get into details in your will. But, the judge is going to follow the family line. So it's typically going to be someone you would hope it would be. We'll get the first opportunity, but if you have a real preference, put it in your documents. Okay. There was a slide we skipped. How long does the guardianship process take? When do I start? It depends where you are. Typically, you're looking at 2 months, but it could be 4 months. I've seen it as much as 6 months, but that's usually when things get complicated. So I would say if you want to be extra safe and you really are eager to have this done by the time your child turns 18, go ahead and file it 6 months before your child's birthday. You can file it as early as 17 and a half. And then you'll be ready to go. Sometimes it's more quick, it goes more quickly, but you should assume it's at least 2 months. I've never seen, well, we've had a few in under a month, but that's very rare. And by the way, before we get into the guardianship process, I will say there are temporary guardianships that are possible in emergency situations. And in that case, you can get a guardian very, very quickly. Once you file that application for a temporary guardianship, a guardian's appointed within 10 days. But it means you're paying twice as much money, because after you get the temporary, it only lasts a couple months and you have to go back and get the permanent, and you don't want to rely on a temporary. So plan ahead if you can. Okay, let's go through the guardianship process a little bit more detail. We already mentioned the physician CME. That's the first step. That's what I tell everyone before we start. I need that physician CME to make sure the doctor is going to support our application. I'm going to write about the CME in the application. And then we're going to file the application. The application has to be filed within 120 days of the date that your child saw the doctor. Okay, so on that CME form, the doctor is going to say when he or she last examined, and we call it proposed ward. Of course, that's the lingo we use for someone under a guardianship. It's not a great term. There's been talk about getting it changed, but it didn't happen. So proposed ward is someone who we want to go under a guardianship. Once they're under a guardianship, they're referred to as a ward. Anyway, the doctor's going to indicate when they saw the proposed ward, and we've got to have the application on file within 120 days. There are exceptions. If it's for intellectual disability only, we have a longer period of time, but typically think of it, you've got 4 months. So what I mean by that is you don't want to think, okay, I'm on top of this. I'm going to get my doctor to fill this out right now while my child's 16. You're going to have to do it again, because you can't get that on file until 6 months before the 18th birthday. Okay, after the application is filed, the proposed ward is going to be served by a sheriff. Come knock on your door, and it is a waste of money in many cases, but we have to do it. It's the law. You can't waive it. So a lot of times our kids under guardianship, they don't understand what they're getting. They don't know how to read it, but they still have to be served. Family members also have to be served. If it is a spouse or a child, a lot of times we have to have service, personal service, meaning sheriff, it's expensive. If it's a sibling and other relatives, then a lot of times we do that by certified mail. But there has got to be some kind of service or notice to family members. And this is what sometimes can slow down a guardianship. If we don't know where all the family members are, and this would include half siblings, then sometimes this slows us down. And this can sometimes add expense to the case if there's, for example, a parent who's disappeared. And I hate these cases. I hate telling my clients this. They might have a spouse that ran out and is trying to be lost because they don't want to pay child support. we still have to show the court that we've really tried to find them. And there's alternate service. But anyway, that's an important step. Besides that, you also have to get registered with JBCC, the Judicial Branch Certification Commission, and watch a little training online. It's really easy, 45 minutes to an hour, and you'll get a certificate that shows you've been trained, and you file that. And then the judge or the court will also get a copy of your background check that JBCC runs on you. So they're going to check to see if you've got any criminal history. And if you'll go to the next slide, that brings us to the qualification to be a guardian. To be a guardian, you know, it's pretty much anyone can do it as long as they are not disqualified. And the disqualification would be from having a felony conviction, having, you know, some crimes of moral turpitude. The judge can just say, I'm not comfortable with you being a guardian. So you also can't owe money to the ward. So that would be the example of a parent who owes child support and isn't caught up. Well, guess what? They're not going to be appointed as guardian if they're behind on the child support. Or if you're in a lawsuit with each other, say you're all involved in litigation, and that could be as simple as a car accident where you might have differing interests. But there are ways you get disqualified. But for the most part, we can keep people qualified as long as, again, you don't have criminal history or something like that. And then we look at the closest relative. It's going to be what you think. Parents get first right, children, and, you know, close relatives are going to be eligible. Any questions on that? Okay, let's keep going.
No, we're good. We're just, we will send a copy of these slides when we send out the email later today. We will send a PDF of the slides.
Great. Okay, if you go, the rest of the process, if we skip over to number 7, 8, 9, and 10, after, you know, we get registered with JBCC, excuse me, and they run the check on the criminal background check, the other steps we need to make sure are completed are having an attorney ad litem appointed and visiting the proposed ward. So when I file my guardianship application, first thing that is going to happen is the person under guardianship is going to be served. And then after that, the court's going to appoint an attorney ad litem. This is a lawyer that just represents your child or the person who's going to be under guardianship. And so they get their own lawyer. We don't pick who that lawyer is. The court assigns someone. So I might be just working one day and I get an email from the court saying, hey, we need you to be attorney ad litem. And sometimes it's a really convenient time for me and sometimes it's not. And so this sometimes slows it down, because if you get an attorney ad litem who's busy with other things, at times we have a hard time, you know, getting their attention. But this needs to happen. The attorney ad litem needs to go ahead and get appointed and then make a visit. And in some courts, they will file a written report. In many courts, they'll just file an oral report at the hearing. Oh, by the way, there are also court investigators in statutory probate courts. So the bigger counties have statutory probate courts. And in those counties, we will have a court investigator who will also make a visit or maybe a Zoom visit and will file a report. After the child, I keep saying child, but I'm assuming we're talking about adult children here. As soon as the proposed ward turns 18, that's when we can have the court hearing. It's usually a very quick hearing because we've taken care of all the paperwork before. And then at the hearing, the judge will appoint someone as guardian. There will be a bond that needs to be signed and an oath. The oath is just a simple statement. I swear to be a good guardian, basically, and always put that person's interest first. The bond, it is Texas law that anyone under a guardianship, the guardian has to be bonded. It's offensive for some parents, I will say, because we feel like, really, you don't trust me, I need a bond. But it is guardianship law, and it makes more sense when you think of guardianships being really designed for elderly people for the most part who have big bank accounts. You know, we want to make sure that money is protected. So most guardianships are that kind of setup. And because of that, the law is all guardians have to be bonded. And so in my area of the world, I'm out in San Antonio, most of the courts around here, we're typically looking at $100 a year bond, or we can get one-time fee bonds for $375, meaning you don't have to renew it. That covers most of the counties around here. There are some counties that let you sign a personal bond, but those are rare, are pretty rare. Any questions on that? I'm going kind of quickly on this section. I'll keep going. Additional steps for guardianship of the estate. If we are looking at managing money, there are going to be a lot of other steps having to do with reporting what all the assets are and applying for monthly allowances, giving notice to creditors, coming up with an investment plan. But I'm going to go quickly through that since most of us won't have to worry about that. Next slide. How do I renew my guardianship letters? Very, very simple. Getting the guardianship is not simple. It's expensive. It requires a lot of work. But once you have it, it's very easy to keep your guardianship. If it's a guardianship of the person, you just fill out a very simple report. Most courts have their own form, or there's some general forms you can use if your court doesn't have one. And you just turn that in. It's typically $10, $12 to file it. New guardianship letters are maybe $2 each. So for less than 20 bucks, most of the time you can keep your guardianship letters current. And let me make sure I explain that right. So getting the guardianship, those letters will expire. Your letters are the proof that you're the guardian. And they have an expiration date on it, which is 16 months after you're appointed, after you qualify. And the reason it's 16 months is they're going to ask you to do a report in a year, but you get 2 extra months after your year's up to get the report in. And then the court gets 2 extra months to get your letters back to you. So don't wait till the last minute, because there's some time that it'll take to get everything processed. But that's why it's a 16th month expiration. If you don't turn in that report, then you could be removed as guardian. I heard somebody once say, if you don't want to be guardian anymore, just don't do the report. That's a terrible idea, because what that means is the judge is going to appoint someone else to be guardian, and you don't want that. So make sure you do the reporting. If you have a guardianship of the estate, you have to do an accounting. You have to make sure that your bond is current. And in some counties, they want the court monitor report to come in. Okay. Can a guardianship be modified or terminated? We already did discuss this earlier. Yes, it's possible. You can have restoration of rights, partial or total. Contact me if you need more information about this. But again, I'll emphasize you're going to need all that same medical evidence, and you're going to need a lot of testimony to show what has changed. So it is a big deal. What happens to the guardianship if we move? You move the guardianship. The guardianship is tied to the county where the ward is living. So if you become guardian of your child and you move out of the county or out of the state, you're going to have to transfer the guardianship. But once your child has been determined to be an incapacitated adult, you don't have to do all the medical evidence again. You know, that is standard. It's always going to be there that your child is incapacitated. And I say child, you know, I mean an adult child now. That is going to be established unless you go back and change it with new medical evidence. But what's going to have to be updated is, are you in the right county? Have you done your training? Is your bond current for that county? So it typically does require a short hearing, but it's pretty easy to do, especially if you move within Texas. Next slide.
I just want to confirm that even if you move counties, so clearly if you move into Texas and you had guardianship in another state, then that's one reason it needs to be updated. But in the state of Texas, even if you move counties, then there needs to be updates. Is that correct?
That's correct. It's very easy to do, but you always have to have your guardianship in the county where the person under the guardianship is living. And so it's simple, but contact an attorney and just get it transferred. Sometimes the court will do it for you, but typically you use an attorney and have a very short hearing. And again, that's because some counties handle the bond differently. It used to be you didn't have to do that training. So if you were a guardian many, many years ago, you didn't necessarily have to watch that JBCC training. So maybe the new court wants you to watch that. They have their own rules. And so you've got to make sure you've qualified in their county. Okay.
And one more thing, if we have a child that's in a residential facility, say they're in Utah or they're in Florida, mom and dad live in Texas, and that example, that guardianship, if the child is, the individual is living in Florida, then that guardianship would need to be in Florida in that particular county, not in Texas where the parents reside, correct?
Well, that's a good question. It kind of depends on what the residence is. If this is just a temporary out-of-state situation and the child's going to be returning, you could argue that the residence really is back in Texas. So that's going to be case specific. How long is the child going to be gone? And a lot of times what will happen is you stick with the residence, the permanent residence. But it's going to complicate things on getting that child served. And so Sometimes we do it one place and move it back. So it just kind of depends on the specific case. Good question.
And I know we're going to go to the next slide here, but can you just talk about, because we were talking about serving other family members and stuff like that, and you talked about the the certification that the doctor has to sign. But what if we have an example of an estranged parent that lives out of the country, number one, or what if we have a divorce situation where the other parent, maybe it's like a joint custody arrangement, and the other parent is adamantly against guardianship? Can you talk about that?
Sure. Well, that unfortunately means sometimes that you have a contested guardianship and a bit of a fight. So first of all, before I talk about the contest, I do want to note, if you are divorced, it is possible to still be co-guardians. Some judges really don't like that. And it rarely works, but I have several situations where we've done co-guardianship for divorced couples. And that works if you are really in agreement on how medical decisions should be handled, on all the issues. And the judge is going to want to know that you are in agreement on those issues. But typically, it's difficult to be co-guardians if there's a divorce. And so one parent is going to apply for the guardianship. And sometimes we get in a fight either over who is the best parent to be guardian, or is there even a guardianship necessary? And at that point, that's where if you're arguing there's no guardianship necessary, that's where you would bring in all the evidence of alternatives that will work and why they will work. If you're arguing that a guardianship is necessary, then of course you're showing why things are not working, giving evidence about how a doctor wants a guardianship, medical decisions that need to be made, or whatever the specific situation is. But sometimes it ends up in a contest. You can go all the way to a jury trial. I hope not, because that's really expensive and it takes forever, but there are fights that get pretty expensive like that. The other thing I would say, as far as serving the parent, you have to serve that biological parent, or you have to show the court you tried real hard. And that means no matter where that parent is living, if they're overseas, you still have to get them served. And this can be really expensive and just a pain unless that parent will sign a waiver. If that parent will sign a waiver and say, look, I know this guardianship is happening, I'm in favor of my spouse being the guardian and I'll support that, that's going to save everybody a lot of money. But it doesn't always work. And as I mentioned before, sometimes we've got missing parents and we have to show the court we tried real hard to track them down and get some kind of substituted service where we publish something in the paper or something like that. Did that answer your question?
Yes, for sure. Thank you.
Okay.
We've definitely had that one come up multiple times, and hopefully you don't find yourself in a contested situation, but I just wanted to put that out there because we've had it come up. Yeah, it's unfortunate. Okay, we're kind of running short on time, so I'm going to go really quickly through these last couple of slides. This is a common question, why does this have to be so expensive? It is expensive. And that is certainly one advantage to powers of attorney. You can do those, if you do them even with an attorney, you're looking at a few $100s, maybe $300, $400, something like that for most attorneys. But if you are in a guardianship proceeding, you're looking at thousands of dollars. And I would say, to just give you an estimate, most of the guardianships in my area, by the time you pay for my attorney's fees, the attorney ad litem, the bond, all the court costs, you're looking at anywhere from $3,000 to $4,000, and I'm actually pretty inexpensive. So it can be much higher than that with many other attorneys. So it is pricey. The reason it is so pricey, let's get into that in the next slide. You've got to pay for your own attorney's fees, and then you as the applicant are paying for the attorney ad litem. Even though you don't pick that lawyer and you don't control what they charge, the judge is going to ask you to pay that cost. Filing the application is anywhere from $275 to $480, depending on your county. So it's very expensive just to get it started. And as I mentioned, the bond also adds another cost, usually at least $100 a year or a $375 one-time fee. But that depends on your county, how the bond will be handled.
There's additional costs if we need to hire a private investigator to find somebody or do certified mail. And as I mentioned before, accountings are required for guardianship of the estate. So just a reminder, guardianship of the person, it's not going to be expensive in the going forward years. Guardianship of the estate, you're going to be hiring an attorney every year to get those accountings in. And if you do have very limited income, there are ways where we can get court costs waived for you. So it's not always that expensive if you're very limited income, but you have to be really right around the poverty line or below before we can get your court costs waived. It's not easy to do.
Okay, we had a question. Hold on one second. Let me get back to it. A person said, I got guardianship in 1982. Is it still good? Basically, if she's been filling her forms out every year, it's still good?
Well, it should be good if you've been doing your report, but you should be getting new guardianship letters. So I would contact the court. What should happen is you turn in your report and then the court will mail you updated guardianship letters. So if you don't have those updated letters, you should check with your court and make sure you can get those. But as long as you're turning your report in and then there's no reason to have that guardianship expire.
We have another thing in the chat box. Basically, got a child on the autism spectrum, high functioning, might need guardianship, might not, doesn't want to hurt his future. And this actually, I think, is a kind of a one-off. I recommend that everybody's situation is a little bit different. And what I would say is Alison's very experienced in these one-off situations. So she may be able to help and guide you. And that's what these attorneys do. They're going to be able to help guide you in the right direction. But because of the change in the law in Texas, I mean, again, you guys are looking at the least restrictive options available and what's needed for that person. So they can, Alice can definitely talk through that with you.
Yeah.
Okay.
Oh, sorry, I didn't mean to cut you off, Allison. I was just going to say that next slide it is exactly that. It is a tough decision for a lot of people. I'm one of those parents in that situation. It's very hard to make that decision. And honestly, there are sometimes I think my daughter is not under a guardianship currently. And there are some times when I think I'm going to go do it. Other times I say not yet. It is really hard. So if you need someone to bounce it off, I'm happy to talk to you. And the last slide does have my contact information. If you want to write that down, you're welcome to call or email. I'm certainly not an expert on everyone's individual situations. I can tell you my experience and my professional opinion, but we know our kids better than anyone else. And so we need to honor each other's choices on this issue. For some people, guardianship is obvious. For some people, it's obvious that there should not be a guardianship. And for a lot of us, it's a close call, and we have a lot of factors that we weigh to make the best decision we can for our kids.
Thanks for sharing that, Allison. I will say that I had the pleasure of hearing, before I sat in the Texas Partners in Policy Making with Alison, I had the pleasure of hearing her speak at the UT Special Needs Conference, and so she's really great, and I love referring folks over to you, Alison. So do reach out to Alison, ask questions, and I really strongly believe that she's going to lead you in the right direction. But one thing I will say is this. These kind of things are not a do-it-yourself thing. It's not a do-it-yourself fix your own special needs trust, first party and third party. You will mess it up. And I'm not saying that rude. There's some things that you can do yourself. I mean, you could probably download a power of attorney and healthcare power of attorney from the internet. I mean, those are some things that you can do yourself. But your situation is unique with a special needs child. It is specialized. It needs specialized care. So just like if you had a heart problem, you're not going to go to the PCP or a foot doctor to get your heart looked at. You have a specialized situation with your child, and the moves that you make matter and affect the benefits. So, I definitely recommend that you reach out to an attorney that is focused on special needs, as opposed to an attorney that says, yes, I can do that. It doesn't mean that that's what they do on a regular basis. They may be specialized in other things. And what we have seen is some of those documents that have been created by attorneys that aren't focused at all in special needs, that they're just flat out wrong. and then you end up having to pay, you know, someone who is focused in special needs to redo those documents. So that's some of the things that we've seen along the way. We don't have a lot of time for this kind of this checklist here, but basically these are some things that should be on your radar as it relates to transition planning. One thing that we didn't talk about that I want to just mention, and we can go deeper on another time, but if you have child support, Texas is a state that often continues child support post-18 if you have a special needs loved one. That child support will be counted against your child for SSI purposes once they turn 18. And so there is, you know, a way to redirect that to a first party special needs trust so that they will still maintain their eligibility. So that is just something that if that is your case, and you do have child support that is going to continue post 18, that definitely needs to be on your radar as well. And you will have to talk to an attorney because it will need to be a court order to get it redirected. But that needs to be on your radar to make that happen, or they won't necessarily qualify. This is our team here at Consolidated Planning Group. We're all here to serve you, and we're happy to be a part of your planning process. And here is our contact information. Our checklist over there of all these things that should be on your radar. We have YouTube presentations on our YouTube channel, basically of every single one of those topics. So if you've missed one, feel free to go out and check those out. And we do try to put webinars out on a pretty regular basis, usually weekly, on these topics. So we hope that you will join us again. Thanks so much, Alison. Thanks so much, Alejandra. We were laughing about being the A crew today. But Alison, this was a wonderful presentation and really, really great information. And thank you for sharing with us today.
Thank you, everyone.
Yes, definitely. Thank you both so much for this wonderful information. It's always useful. We always get so many questions about it. So it's great. You get a new experience, new information every day. So thank you both very much.
Thank you, everyone. Have a great afternoon.
Bye-bye.
Bye now.